Very good evening, students. Good evening, everyone. Please confirm about the voice and the video, and I'll start the session. Any volunteer, please confirm about the voice and the video in the comments. Yes, students, I hope I'm audible and visible to you all. Okay, thank you, Diksha, for clarifying that. On that note, let's begin with this class. So, first of all, I welcome each one of you to my class on the mock test of criminal law. So let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Here is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. I have also shared the link of my Telegram channel, which you can use to get connect with me. If you have any questions, any queries, you may post your questions on my Telegram channel as well. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. I request everyone, please be attentive, and this is going to be an interactive session. So what all we are going to do today is MCQs on criminal law. Okay, so I have total 50 questions MCQ today, 30 questions on Indian Evidence Act, 10 questions on CRPC, and 10 questions of IPC. So let's begin with the test. Student, before starting this MCQ test, make sure whatever your answer is, first do write down the question number, numeric 1, and then whatever your answer is. Here comes the first question. Which one of the following is irrebuttable presumption out of all these options? Very good evening, Shivangi, and everyone, those of you who have just joined. Conclusive proof, may presume, shall presume, both A and B. Okay, the first answer which I've got is from Shivangi A, Pratyush A, and Simrat Kaur A. And the answer is correct. This question is basically from section number 4 of Indian Evidence Act, and conclusive proof is irrebuttable. Okay, next one. Which one of the following is rebuttable presumption? Out of all these options, the options are the same as the previous question. Conclusive proof, may presume, shall presume. Which one is the rebuttable presumption? Simrat, Pratyush, correct answer. May presume and shall presume. Both can be rebutted by the party. So the correct answer is D. Both B and C. Facts which form part of the same transaction are relevant under section. Basically, it is asking about res gestae, the maxim, the famous maxim. under section number. First one to answer correctly, Shivangi, followed by Pratyush and Simrat. Yes, B is the correct answer. That is section number 6. Admissions are. When it comes to admissions, under Indian Evidence Act, the term admission has been defined under section 17. So choose the most appropriate option. Not conclusive proof of the matters admitted. Conclusive proof not to operate as estoppel or of no value. First one to answer correctly is, okay, Meghna Mohan. You have answered B as well and A as well. So I'm taking the right answer. So A is the correct answer. Okay. So it's A. Admissions are not conclusive proof of the matters admitted. If you are wondering the section number for this question is basically from section number 31 of Indian Evidence Act. I hope now you can easily connect. Okay. So admissions are not conclusive proof. Okay. But it will operate as estoppel. Okay. Next one. Confessions made after the inducement, threat, or promise has been fully removed. It is relevant under section. Choose the most appropriate option. Okay, first one to answer correctly, Pratyush, followed by Atif and Meghna Mohan. So C is the correct answer. Students, 24 is not the correct answer. So you have to read the question carefully. The question is talking about confession made after inducement, threat, or promise, which has been fully removed. So if that has not been removed, confession is not going to be relevant under section 24. But if that has been fully removed, that will be relevant under section 28. So C is the correct answer. Okay. Next. Section 32 does not speak of which of the following kind of persons. Top 3 students to answer correctly, Pratyush, followed by Mahesh and Padma. Everyone's answer is correct. That is D. The person who is unwilling to give evidence. See, there is a list that has been provided under section 32. If the person is dead, cannot be found, incapable of giving evidence. So A, B, C will fall under 32, but not D. Which one of the following section makes relevant opinions as to existence of custom? So it's a direct section based question. Existence of custom is relevant under section. Top three students to answer correctly: Atif, Meghna, and Mahesh. And everyone's answer is correct. That is B. Section number 48. Facts judicially noticeable. Choose the most appropriate option. Need not to be proved, need to be proved, may be proved, must be proved. Those of you who have answered correctly for question number 8, please do mention the section number as well. Meghna, Atif, and Padma, top three students to answer correctly. And yes, A is the correct answer. If the facts are judicially noticeable, that need not to be proved. Court can take judicial notice of. Choose the most appropriate option. Amitabh Bachchan is a famous actor. M.F. Hussain, famous painter. Bentham was a renowned jurist. D. None of the above. For which of the following the court can take judicial notice of? Just a second, students. Actually, okay, now it's fine. Now it's fine. Okay, now I can see your answers. Yes, Pratyush, first one to answer correctly, followed by Sonia and Atif. Yes, D is the correct answer. D is the correct answer. The details of an incident printed in a newspaper are categorized as. So, suppose if you are reading a newspaper and there is an article on that, so that article will fall under where? Documentary evidence, indirect evidence, hearsay evidence, relevant evidence. It's an important question for PT as well as your mains examination as well. First one to answer correctly is Shivangi, followed by law knowledge, C, and Atif. Yes, everyone's answer is correct. That is C. That is going to be treated as hearsay evidence, and hearsay evidence is no evidence, right? So for oral evidence, it must be direct, but when it comes to hearsay evidence, that is indirect, and that is why that incidents will be treated as hearsay evidence. Tape record statements are documentary evidence, oral evidence, both A and B, none of the above. Top three students to answer correctly. Law knowledge, A, followed by Atif and Shivangi. A is the correct answer. Yes, A is the correct answer, students. Documentary evidence. Okay, I have a counter question for you all who have answered correctly. Why tape recorded statements are documentary evidence? Where it is written? Can you give me any section where it is written? Yes, please. I have a counter question for you all. Whosoever has answered correctly or even incorrectly, if you can answer, you can write in the comments. Why tape record statements are treated as documentary evidence? Okay, Vikram, I have taken your question. I'll give you the list of important sections. Very good evening. Law knowledge makes life easier. Yes, I have not received the answer till now. It's not that difficult. J- uh, See, students, when someone is asking you a question now and a counter question for the reasons of your answer, that can be defended by two ways. First, obviously the section number, and the second one is obviously the case laws. But there is a section number for this one. R.M. Malkani. Okay, you are referring the landmark judgment. Okay, let me give you the answer. See, when it comes to section number 3, that is interpretation clause, and in section number 3, there is a term that has been defined which is called evidence. Okay, the term evidence has been defined, and that evidence includes documentary and oral evidence. And when you will read the definition of documentary evidence there, all the electronic evidences are included in documentary evidence. So that is why tape recorded statements are treated as documentary evidence. Okay, and again, you may refer, the landmark judgments as well. Like R.M. Malkani is very, very important, and I can say repeatedly has been asked in your examinations. Okay, so moving to the next one. Which section is related to res ispa loquitur? So it's a maxim which means things speaks for itself. It's like people may lie, but not the circumstances, right? Human beings may lie, right? But circumstances never lie. So things speaks for itself. Right? Pick up the most relevant section related to this maxim. Okay, top three students to answer correctly is Pratyush, Padma, and Mosumi. Yes, 106 is the correct answer. C is the correct answer. Kunal, please do correct yourself. It's not B, it's section 106. Okay. Vikram, I have taken your question. Okay. Now, first, let me complete the question for this class. Okay. I'll give you the list. Don't worry about that. Section 112 applies when there is a dispute regarding maternity of child, paternity of child, both A and B, D, either A or B. It's an interesting question, by the way. And even if you don't, if you have not gone through section 112, even then I can tell you, you can answer this question because it's completely logical. Top three students to answer correctly: Pratyush, followed by Vikram and Ayush. And I can see every single one, each one of you has written B only. Done. So the answer is correct. B. It's paternity of the child. See, it's always the paternity that is in the question, right? The maternity of the child is very much clear, because of the relationship between mother and the child. The mother is the one who has given the birth. So there's no question, there's no doubt about that. It's always the paternity which is in the question in the court of law. Section 105 will apply to criminal trial, civil suit, both A and B, none of the above. So if you can recall what section 105 is, you can easily answer this question. $15. Okay, I'm surprised. Okay, rest is fine. Shivangi, Simrit, and Amandeep, top three students to answer correctly. Yes, 105 will be applicable to only criminal trial. See, 105 is basically burden of proof. Burden of proof in relation to chapter number 4 of IPC, that is general exceptions. So 76 to 106. So suppose if there is an accused and that particular accused feels that his case falls under any of the general exceptions under chapter number 4, so the burden of proof to prove that point in the court of law that my case falls under this particular general exception, the burden is always on the accused only. So the answer is criminal trial. Okay. Next one. Presumption of section 113A pertains to. Ayush, you have asked what is ossification test. This test is basically done to know the correct age of the person, and that is through bones of the person. Okay, even if suppose if we have found a skeleton, we because of with the help of that skeleton we can assume we can actually uh, easily find out the age of that person. So finding age of a particular person with the help of bones. (16) Okay, I need to see presumption of 113A. Okay, see. Shivangi, Atif, and Pratyush, top 3 students to answer correctly, and yes, C is the correct answer. Okay, Alex, take some illustration from IPC, sir. Alex, please complete your question. Which illustration do you want from my end? Okay, I'll give you the illustrations. Okay. Ayush, for that I need to cross check whether you can determine paternity with that or not. See, paternity can be done through DNA test, through hair sample. Okay, that I can confirm with you. That I can confirm with DNA test, with a blood test through DNA. Okay, or even if you got a hair as well, then you can easily find out whether there is a paternity or not. So C is the correct answer. (113B) was added in. Usually there is a confusion, so I can give you a trick for this one. Usually students got confused ki what is 113A and what is 113B of Indian Evidence Act. So I can give you a trick for that. If you can recall what is section 304B of IPC, and if you can connect that with 113B of Indian Evidence Act, that will make your life easier. Okay. Amandeep, Anumitro, and Sabkuch, top 3 students to answer correctly, that is 1986. So basically the presumption related to dowry death. And even you should know that when it comes to section 113B, what kind of presumption that is. May presume or shall presume. And when it comes to section 113A, what kind of presumption is that? May presume or shall presume. That can be also a very good question for your PT examination. Okay, this is very, very easy. Estoppel has been defined under section. First one to answer, Anumitro, followed by Shivangi and Padma. And yes, B is the correct answer. Section 115 defines the term estoppel. Who is not a competent witness out of all these? And trust me, it's a previous year question. This is not my question. I have not made this question up, just for the clarification, right? It's a previous year question. And there's a strong reasoning as well behind the answer. Now, please do answer. Okay. 19, when it comes to 19, okay, there are students who have written B and some students have answered D. Okay, let me ask you a counter question. If you are answering it B, dumb is not a competent witness, give me your reasons. And if you are answering D, idiot, give me your reason. Why? Why idiot is not a competent witness? Why dumb is not a competent witness as per to you? Okay, Alex, for last some classes I was taking only IPC. That's why I'm in this particular class I'm taking Indian Evidence Act. Yes, there are some questions of IPC as well in this class. Shashikant, you have given me the reasoning but not the answer. So what's your final answer? D or B? Okay, now let me answer. See, the correct answer is D. Idiot is not a competent witness, and the reason is completely correct. That is given by Shashikant. That is, see, there is only one eligibility to be a competent witness. That person should understand the question and answer rationally. And when it comes to idiot person, the problem with idiot person is that he cannot understand the question. And if you just cannot understand the question, then you can never answer rationally. And that is why idiot is not a competent witness. I hope now you will remember this. Next one. Who is accomplice? In English law, there is a term that has been used, accessory. Okay. In Indian law, we use the term accomplice. Atif, Anumitro, and Shivangi. Everyone's answer is correct. Everyone is answering C only. And yes, that is correct. Participate in the commission of crime with charged accused. Which of the following is not privileged communication? Correct section number, Pratyush, 133. Anumitro, Sunita, and Atif. Top three students to answer correctly, and that is B, which is paternal. When shall the witness be re-examined? Top three students to answer correctly, Anumitro, followed by Atif and Sabkuch. Sunita and Padma Law, please do correct your answer. ठीक है जी? Done. Please do correct your answer. The correct answer is at the desire of party calling. Okay. What number of witnesses will be required for the proof of any fact? Okay, there is a famous story as well, which has been associated with this question. So I'll tell you the story as well. So first you answer the question. And starting from Anomitro, everyone's Sunita and Shivangi, top three students to answer correctly. A is the correct answer. Done. Padma, please do correct yourself. There is no number required. Okay, it's not about the quantity, it's about the quality. Okay, let me give you one example for this one, and you will remember this concept for the rest of your life. There was a time in England where it has been said that if a particular fact has been stated by 11 or more than 11%, then that particular fact will be considered as a truth. Okay, but the story which I am telling you, it is about a long ago, right? Because now in 2022, or when we can say in 21st century, this kind of rules will not be like work because of obvious reasons, right? देयर वाज अ टाइम कि मतलब प्राण जाए पर वचन ना जाए. ओके, लोग अपनी मतलब कहकर पलटते नहीं थे बातों से. तो ये तब की बातें हैं, तब की स्टोरीज हैं. बट नाउ, एज ऑफ नाउ, you may get a case loss where even there is a one eyewitness and that is completely sufficient and the person has been convicted. But there are again cases where there are more than 10 eyewitnesses, but still the person has not been convicted because it's about the quality and not the quantity. So section 134. Next one. What is the object of cross examination? Why do we have the concept of cross examination? Yes, Sashikant, completely correct. Evidence evaluated, not counted. Starting from Anumitro, Atif, and Padma, top three students to answer correctly. And yes, D is the correct answer, to examine the credibility of witness. Hostile witness means top three students to answer correctly. Anomitro, followed by just a second. Anomitro, followed by Sunita and Atif Mohammed. A is the correct answer. Amandeep Singh, please do correct your answer. D is not the correct answer. And yes, let me tell you this as well. There is a myth in relation to this question that hostile witness is the one who is lying in the court of law. No, that is not what hostile witness is. Hostile witness means that whosoever party has called that particular witness, that is passing such statements which is favoring the opposite party. So basically, it's an unfavorable witness. Hostile witness has nothing to do with the truth or the lie. Okay, so the correct answer is A. Which of the following statements is correct? Which of the following statements are correct, by the way? Yes, judge may ask any relevant question to anyone. Judge may ask any irrelevant question to anyone. Both, none of the above. Tilak Karki, yes, in a layman language, for your understanding, you can, for your own understanding in the brain, not to, write in the mains or to say in the interview. Yes, you can use the word dhokebaj. 26. Sab kuch first. Okay, no, not sab kuch. 26. Sunita, first one to answer correctly, followed by Sabkuch and Anomitro. Yes, C is the correct answer, students. Judge may ask any relevant or irrelevant question to anyone, okay? Because obviously he's a judge, right? You cannot say, sir, Judge Saab, it's irrelevant. No. So judge may ask any relevant or irrelevant question, and this is in under section. Anyone can tell me the section number for this one? Yes, section number for this particular question. Yes, Anometro, correct. Ledley 165 is the section number. So section 165. जो जिनका भी ये question गलत हुआ, whosoever has not answered correctly, please do refer section 165. And there is one minor point as well here. The judge can ask questions relevant or irrelevant, that does not matter. But when it comes to the judgment cannot be based on irrelevant questions. Next. Order of examination. This is, I think it's very, very easy. What is the order of examination? Like first, second, and third. Basically, the formatting of examination. Numbering. Anomitro, Amandeep Singh, and Atif. No, Atif, you have answered A. It's wrong. Anomitro, Amandeep, and Shashikant, top 3 students to answer correctly. So D is the correct answer. Husband and wife shall be competent witness. Husband and wife shall be competent witness against each other. In which cases? Civil, criminal, both, none of the above. Everyone's answer is correct. Anometro, followed by Amandeep and Ledley. Yes, C is the correct answer. Padma, please do correct yourself. C is the correct answer. Clerk and servant of barrister is in privileged communication under section. Anomitro, Shashikant, and Padma Law, top 3 students to answer correctly. Yes, it's C. C is the correct answer. Atif and Sabkuch, please do correct your answer. Pratyush and Amandeep as well. See, B is not the correct answer, students. There's a difference between 126 and 127. Under section 126, there is a privileged communications. Okay, between basically related to your professional communication. Okay, then between an advocate and a client, that will fall under 126. But if there is a clerk or servant of that particular barrister, that will fall under 127. So the correct answer is C here. Power of jury or assessors to put questions. There is no jury trial, by the way, in India as of now, but still there is provision, and this has been asked in your previous year questions. So that's why I have included this. Anomitro, Sabkuch, and Tilak, top 3 students to answer correctly. Yes, B is the correct answer. 166. Shashikant, please do correct yourself. Okay. Preeti, it's not 165, this is 166. Procedure in case of accused being lunatic. Now we are talking about CRPC here, students. So in CRPC, is there any kind of a special procedure when it comes to, accused being lunatic? If yes, under which section that is mentioned? Yes, Sunita, completely correct. The last case was of KM Nanavati, the famous one. There is a movie as well on this of Akshay Kumar, Rustam. And it's a landmark judgment, by the way, KM Nanavati. And usually we read this in the exceptions, section 300, exception 1. And you can read that judgment in private defense as well. Sunita followed by Anomitro, correct answer D. Preeti, yes. Monica, correct answer D. 328. Victim compensation scheme under section. It's an amendment. You should know the amendment year as well for this particular question. Okay, Anometro, Ladley, सब कुछ correct answer. A is the correct answer. When the court of session passes a sentence of death, the proceeding shall be submitted to dash under section 366. This section is usually read with section number 28. Read with 366. Read with 368. So in the combination of all these three sections basically completes the concept. Padma, Sashikant and Sabkuch, top 3 students. Okay, no, उससे पहले आंसर किया हुआ है जी. Tilak, Amandeep and Ladley. Yes, B is the correct answer. Everyone's answer is correct. Compensation to persons groundlessly arrested. So in short, if the person has been arrested without any grounds, that particular person will be awarded the compensation as well. So he will get the compensation under section. It's an important chapter starting from section number 41 till section 60A. The grounds of arrest. Just a second, I'm just confirming one thing. Okay. So for question number 4, A is the correct one, students. Tilak, Ladley and Anomitro. Top 3 students to answer correctly. A is the correct one. Okay. So it's section 358. Under which section of CRPC the provision for reference to High Court is given? So the C is the correct answer, students. Section 395. C is the correct answer. When High Court or any session judge calls for to examine the record of any proceeding before any inferior criminal court, it is known as. Tilak, please mark my words, okay? There is no concept of review when it comes to CRPC, okay? Reference, review, revision, all three are in your CPC, but when it comes to CRPC, there is only reference or revision. Can anyone tell me why there is no concept of review under CRPC? Anyone? Why no concept of review under CRPC? And by the way, the correct answer of question number 6 is C. So C is the correct answer. Yes, anyone can tell me why there is no concept of review under CRPC? Waiting for your answer. Because when it comes to criminal cases, okay, so what is basically, first you need to know the meaning of review. Review is the same judge is looking into the matter, again. He's reviewing his judgment. So when it comes to CPC and CRPC, when it comes to CPC and CRPC proceedings, the major difference is, when it comes to CRPC, there is a life of a person is on the stake. Okay, so that is why there is no concept of review, which means if a judge is passing a judgment at a CRPC, there is already a pressure there, and there is no need of concept of review there. Okay. Next. Which section of CRPC has dealt with power of High Court to commute the sentence of pregnant woman? Tilak, Sunita, and Sashikant, top 3 students to answer correctly. A is the correct answer. In bailable offence, the bail is granted as a matter of right. Amandeep, Ladley, and Sab Kuch. So C is the correct answer. Anomitro, if you go by the language of the Bayer Act, the term that has been used is and, not or. Okay. The bail granted to a person who is apprehending the arrest is called. And everyone's answer is correct. That is anticipatory bail. Yes, I can see even you have mentioned 438. Perfect. C is the correct answer. Anticipatory bail under section 438 can be granted by who may grant the anticipatory bail? Santani, please do a refresh. Please do a refresh. And yes, Court of Session and High Court both can grant anticipatory bail. A says Z is an honest man. So these are basically now the last 10 questions from IPC. He never stole B's watch, intending to cause it believed that Z did steal B's watch. A has committed which offense? Anumitro, Sunita, and Ladley. Top 3 students to answer correctly. बहुत बढ़िया. Section 499. Offense of defamation relates to harming. What basically defamation caused? Association of persons, property of a person, family of a person, or a reputation of a person. Everyone's answer is correct. That is D. Starting from Tilak, yes. Reputation of a firm. Which one of the following are the exceptions of defamation? Everyone's answer is correct. That is D. Amandeep, please do correct your answer. These all are the exceptions. And how many exceptions are, by the way, under section 499? That is defamation. The number of exceptions that has been given under section 499. How many? The number. And this is also your one of previous year question. C is the correct answer, students. Yes. Total 10 exceptions. A threatens B to injure the reputation of C, a deceased. Okay? A deceased in whom B is interested. A has committed. So can you commit the offense of defamation against a person who has already died? And yes, it's again a case of defamation. B is the correct answer. What is the punishment for criminal intimidation? D is the correct answer, students. D is the correct answer. 2 years. Yes, Shashikant, under section 199 of CRPC, the cognizance may be taken by the session court, but that requires a lot of conditions as well. You know, the person who against whom defamation has been committed, that must be from the VIP list, basically the Prime Minister, the President of India, and so on. Minimum duration of imprisonment provided for an offense under IPC is minimum duration, that is basically for 24 hours of imprisonment. So that 24 hours of imprisonment has been provided for an offense under section. Perfect. Everyone's answer is correct, starting from Anomitro, followed by Tilak and Sunita. A is the correct answer. Attempt to commit offenses under chapter and section number. So attempt is mentioned under section number and the chapter number. First the chapter number and then the section number. So basically the last section of IPC and the last chapter of IPC. If you can recall that. Wonderful, Sunita. 10 rupees of fine and 24 hours. Bahut badhiya. Everyone's answer is correct. That is A, 23rd chapter and section 511. Section 511 does not apply to attempt of which of the following? And yes, D is the correct answer. Starting from Anomitro, everyone's answer is correct. D. Because we do have a separate section for attempt to culpable homicide. Attempt to commit any offense is punishable with dash of the term of imprisonment provided for the offense. So this question is basically from section 511. So what is the punishment under section 511? And the options are basically half of imprisonment, 1/4 of the imprisonment, 1/3 of the imprisonment, full imprisonment. Shashikant, please do correct yourself. Lately, please do correct yourself. The correct answer is A. A. When it comes to the punishment for attempt offenses, as per to section 511, we do half the punishment. So for example, let me give you one example as well here. So suppose attempt to theft. Now the punishment for theft is 3 years, right? As per to section 379, the punishment for theft is 3 years. Now suppose if the attempt for theft, then the punishment will be half. So basically the maximum 1.5 years. Okay, so the correct answer here is A, half, one half or a half, whatever you call it. Last question. A puts his hand in the pocket of B for stealing money, but the pocket was empty. Bad luck. A is guilty of, which means the first pocket was empty and then he got caught as well. Wonderful. So now A is guilty of. And the correct answer is D. So now anything which you are not clear with. So students, I have to share one important information for you all. There is All India Judiciary Scholarship Test, which is going to happen on 13th of November, 11 a.m. This is completely free of cost. So if you have not enrolled yourself till now, make sure do it as soon as possible, because you can win exciting prizes and you can win 100% scholarship. So it's like a win-win situation. Make sure you don't miss this. Now anything if you want to ask. Sashikant, I am going to share the complete schedule of my YouTube classes for the month of November in advance on my Telegram channel. Okay. So for my Telegram channel, what you need to do is just open the Telegram app and search for Sandeep, Sandeep, then my surname, the first letter of my surname, K, and then UA, and you will reach to my channel. Okay. So Sandeep K UA, just search for that, and you will find the complete schedule. Now, anything else which you are not clear with, you may ask. Uh, I just want to tell you this as well, that on our academy there is a judiciary test series calendar. So you can see in free as well, there is an accelerate test series for major law, 8 tests per month. Challenger series, 4 tests per month. This is completely free. This is all for the plus students, and this is all for the iconic students. Thank you everyone for the kind comments. That really means a lot. Thank you, Ladley. You're welcome, Preeti. Tilak, the link. Okay, just give me a second. Just give me a second. See, here is the link of my Telegram channel, the complete link. But you can search me with this as well, Sandeep KUA. Or if you want the complete link, here it is. Done, Tilak? Anything else? Uh, Isha Law Study, if you want to join an academy, here is my code. As you can see on the screen, Khatri10. Khatri is basically my surname, Khatri, and 10 is the 10% which you will get the discount of. You can see on the screen as well at the end, my code. I hope I have answered everyone. Chaliye ji. That's it from my end. So see you in the next class. Till then, yes, it's time to say peace.